So last time we were moving our way through the Bill of Rights, and we talked last time about search and seizure and um, due process and probable cause a little bit. That there needs to be probable cause, and that to have a search warrant issued, or even to do a warrantless search, there's some exemptions to that. That for safety of the officer and other folks on the scene, they can do an immediate search. We talked about the exclusionary rule some, right? The fruit of the poisonous tree. So search done without proper um, process, without due process, without the probable cause part, um, would be whatever's found would be excluded. Some of the exemptions to that would be if it were already in public and was going to be found anyway, that kind of thing, to get rid of, to give it a little bit of common sense into it, right? So if it's visible through the window of your house, then it's right, that's public. So you could get it that way, or if it were incident to a public safety search, right, something like that, you could get it. But otherwise, if it's gathered illegally, then if the search is done illegally, the seizure is done illegally, then whatever that was seized would be thrown out in the court case that would be brought against you. And so that's really all we were going to cover on search and seizure. And wanted to move on now to the Fifth Amendment, which is the amendment that gives us the ability to prohibit the government from forcing us to incriminate ourselves. Right? The clause is, no person shall be compelled to be a witness against themselves. And the idea here is that if the government is going to bring a charge against you, they need to be doing the work, right? They need to prove their case. They can't accuse you of something and then force you, right, to prove that you're not guilty, first off. Right, they have to prove you are guilty, and therefore, right, you're not ever going to be compelled to have to witness against yourself, and you can choose whether to witness even for yourself, right? One of the things that we have the right to do is say, I ain't saying nothing, and make the state prove their case. We see the practical application of the Fifth Amendment come out through what we call today, we refer to them as our Miranda rights. They came out of a court case where the accused last name was Miranda. And so the Miranda rights are the actual breaking out of what this Fifth Amendment means in practice, right? Here are the rights you have. You have to be made aware of those rights at the point that you're arrested, right, for or through an accusal or accusation that you broke the law, right, and they're arresting you to make as an official suspect. So those Miranda rights are there to make sure that you, as the accused, are aware of at least the minimal amount of rights that you have to protect yourself from the government when you're accused of a crime. And that's what we see. People, the police will hear, you have the right to remain silent, you have the right to an attorney, you have to, that spiel that you hear on TV all the time is mostly correct, right? And we actually train our police officers to do that anytime that they think that arrest is imminent, even if maybe they change their mind, because it never hurts, right, to put those out there ahead of time. As a matter of fact, we give them a card to read so that they can do it in a prescribed process that ensures they deliver it the right way, right? As long as they'll follow that, they'll have done their due diligence in providing your rights to you, at least the knowledge of your rights that you have. So we want them to do that and to put them out there. The interesting thing here, or one of the interesting things here that I've mentioned before, and I want to bring it out again, is I told you when we were starting to move through these bills to pay attention when an amendment or the Constitution in itself uses the word citizen or it uses the word person, right? And so, and those are different, right? So a citizen is a right or a liberty that's applied to a citizen is applied to people who are citizens of the United States. And so that's a subset of all the people here. But when we use the language person, we mean just exactly that, all people, citizens or not. And so when you're looking at these criminal elements here, right, protections for criminals, most of the time you're going to see the word person being used here. So these rights extend to anybody within the jurisdiction of the United States, whether they're citizens or not, right? So again, it really drives home that these are limitations on governmental action, right? They're because they apply to everybody, not just citizens. It's every person here, right? So, and that's important to keep in mind that some of these things, when our framers wrote them, right, they made a distinction here, and they were extending some of these privileges and immunities and rights to, well, not protections to all people. And the fifth is one where it's really clear that they're saying that. So there's not a whole lot to go on with that. I mean, if it's not done, it's usually going to be something that can be brought up and used as proof that the government wasn't following process the way they should have. They accused you of a crime. And it can reset the process, and it can get you out of trouble if they don't. Like I said, training for police officers, this is pounded into them. We give them every little tool we can to help them remember to do it and do it right. So there should be no excuse for this not happening, right? That when an arrest of someone is going on, that they're made aware of their rights and their ability to not incriminate themselves, right? That they can just give the minimum amount of information, right? And that should be enough. And that minimum amount of information is usually identification of who you are, what you're doing and where you're doing it, right? They can ask a few questions like that, but you don't have to answer anything that would incriminate you on your actions or their beliefs on your actions. So it is incumbent upon you to provide some kind of identification if a police officer asks, but that's about it, right? So, you don't have to tell them that you were breaking the law if you were. You don't have to tell them that you weren't breaking the law, right? That's their problem to figure all that out, right? So, when it comes to answering anything like that that's going to go toward your guilt or your innocence, you do not have to answer that. They, of course, are going to try to get you to answer all of their questions. And your Fifth Amendment, right, gives you the ability to tell them that you're not. Again, just be aware that anytime you choose to be less than what they consider cooperative, they may want to take you downtown and question you and hold you for a while and do that. And if you're going to protect your liberties and your rights, you're going to have to be the frame of mind to do that, right? That or be prepared to have an attorney show up and work you through all this real quick and pay for that privilege. The sixth gives us the right to counsel, which is that attorney privilege that I was talking about there. This authority has been expanded over time, of course, from federal cases to state cases. also now, you know, felonies and misdemeanors. So a lot of states went beyond this to begin with and gave more Sixth Amendment rights at the state level than the feds did anyway. But regardless, it's completely saturated through the states and the federal government now that you have a right to counsel. You should use that. You know, it's again, being able to be successful at this and protecting yourself against the state is somewhat difficult, and it's never cheap. And unfortunately, the fact of the matter is that the more wealthier you are, the better you can defend yourself. It's just true, right? You get the defense counsel that you can afford. If you can't afford one, right, you're going to see that the state will provide that, or the federal government will provide that for you, but that's not what you want. It's not in your best interest. It's better than having no counsel at all, but if you've got any access to money, you should use that and hire your own attorney, not take the one provided by the courts. Not because the ones provided through the system are going to be biased against you, but you're not going to have any assurance that they're really very good at what they're doing. There are some groups of attorneys out there that work with organizations to provide indigent legal assistance, and that's, you know, they work at it hard and they're very good at it. Others, though, are volunteering their time, but criminal law is not what they do for a living. So you may very well, if the court is appointing you an attorney, get someone whose day job as an attorney is that they are a tax attorney or a state attorney, right? That they work in some other specialty and not criminal law. It's just, and I think in almost every state, you know, you're not going to get out of law school and you're not going to pass a state bar exam without having all the basics of criminal law to be able to do that work. But there's a real difference of having studied it, you know, intensely for a year or so 10 years ago and it being your daily job. And so if you can afford someone who is a defense attorney as their primary occupation, you're probably going to get a little better representation than someone that's doing their best, but it's not what they do for a living, right? So they may be a lawyer, but they're not a professional in the defense side of things. I would encourage you, we know, right, that if you can, your money will buy you better representation. So if you can't afford it, you should. If you can't, then you got to work with what you're given. And in that sense, there's, right, I mean, that's a real challenge to the delivery of justice through the system. Any other way of doing it would probably be much more expensive, but it could also be much more on point and do a better job. But we have not convinced ourselves that we should have defense attorneys that are provided for everybody that's their primary focus, right? So states go about it different ways, but in the end, the truth of it all is that you'll get better defense by hiring someone than you will by getting the freebie. And I say this not as an attorney, but as someone that an attorney has told that to, right? That you know, the other side of it that you need to consider is that your opposition in a criminal court case is prosecutor, right? The state is the other party, but the person working on behalf of them is a prosecutor of some kind, district attorney or a state prosecutor or something. And that's what they do all day, every day. So it is their specialty. So you really should be hiring someone that defense law is their specialty, right? So that you can maybe be on equal legal footing once you're in the courtroom. So again, that's not the kind of stuff that you're going to find in the textbook and we're going to apply a test on. But you need to understand what the reality of the situation is. You've got a liberty here to protect yourself and defend yourself, and the state and the government are not going to proceed forward if you don't have counsel unless you explicitly refuse it. But you're not going to be guaranteed of getting the best counsel possible. Does that make sense? Okay. So, trial by jury, one of these protections that we get, right? We are guaranteed to have a trial by jury if we choose to take that route. Very seldom do we actually do that for a number of different reasons. One, it's not usually the case that most court cases are going to make it to trial. Most of them end through negotiations, through plea bargaining well ahead of the trial date. The ostensible reason for that is because the state has enough undeniable proof on their side that people are willing to plead guilty for a lesser sentence, if that's possible, or at least for the consideration of that. And that's a good thing in a sense, because it would be it's a good thing in the sense that the prosecution is bringing enough solid evidence to the court case, to the early parts of the trial, to convince people that, look, you did it, you know you did it, we got proof that you did it, we know you did it. When we get to the courtroom, everybody in there is going to know you did it. And if you can plea bargain, it saves everybody time, money, and effort. Now, that's the good side of plea bargaining, right? Is that it lowers the cost for everybody involved. Unfortunately, that's also part of the cost factor is one of the bad parts about it, right? And someone plea bargaining to a guilty position and taking punishment sometimes can be just tied to the fact that they can't afford, right, to move forward with the trial. They don't have the wherewithal to really do that, and especially if the odds look stacked and they're against them, right? And they're even if they are innocent, and we know this is true, we've had people plead guilty and get lesser charges because they were more convinced that the lesser charges was the best case scenario for them, because one, they couldn't afford the defense, two, they didn't trust in the defense that was provided for them, three, they didn't believe they were going to get a fair trial, and if they lost that trial, even if it was fair, the penalty that they saw on the other end was so much worse than what they were offered in plea bargaining that they didn't want to risk it. So there's a whole lot of reasons that someone might say, I'll take this plea deal even if they aren't guilty. And we know that's happened, right? We've had people who plea bargained, gone to jail, and then later the state and other evidence comes up and proves the case that, oh, we put the wrong person in jail and it was somebody else that did this. And you ask them, like, why did you plead guilty? And it's like, well, right, it was, in my mind, I was going to lose anyway, so it made sense just to take the best possible case. That's a problem with our system. That is an outcome that we see happen occasionally. I don't have any hard numbers of how often that might happen, but 9 out of 10 cases get settled at the plea bargaining stage. Right? So that tells you that there are an awful lot of criminal cases out there that would be susceptible to this. I don't have a number that tells you how many. The fact that any happens is definitely a problem for justice. So 10% or so go forward and do have a trial by jury. The other side of it is that as the accused, you're going to have an opportunity to choose trial by jury or trial by judge, especially in Texas. And you're probably, right, from what we know, going to get, especially if you're guilty, you're going to get better terms from the judge than from the jury. And so that's another part that plays into this, that anybody that's got decent enough counsel is going to tell them, look, if you're not going to plea bargain and you're set on going to trial, we will, but it's probably in your best interest to have a judge, not a jury. 2 reasons for this. One, especially in Texas, Texas juries are really, really mean, right? I'm not going to say they're not fair, right? I can't assert that. But if they, as a jury, decide that you're guilty, they're probably going to throw the book at you as far as punishment goes. Whatever the legal range of punishment is, the Texas jury is going to be on the high side of that. It's just the nature of Texans in general that if once they get to the point of believing that you're the one that was guilty of the crime, they're probably going to start at what's the maximum we can sentence them to and work their way down. Whereas a trial judge that's done case after case after case is not going to be looking to do that necessarily. They're probably going to have a whole history of cases where they've assigned punishment, and they're going to look at that past history as a guide to what to assign as punishment this time. So you're liable to you'll get a more average penalty based upon the circumstances of your case, where with the jury, it's their one and only shot probably in a criminal jury, and the nature of Texans is they're not going to be looking for any kind of average. They're going to be looking for what you deserve. And what you deserve will be, from their perspective, starting on the far end of the punishment side. So the recommendation, I guess, is generally go with a judge, right? The only drawback to that, in a sense, is that it's probably not going to be as swayable by argumentation, where you might be able to sway a jury and possibly get a not guilty decision. Judge is probably seen all that, heard all that, not really going to be moved by that. So in that sense, you give up some of your, swing for the fences opportunities that you might get with a jury, because it's not going to fly with a judge. Does that make sense? Any questions or concerns about plea bargaining before I move on to talk about jury selection? So this is just a thing that interests me, and I like to point it out because it might be interesting to some other folks. That after you decide I'm going to go to a jury trial, right? And I've been accused, and I'm going to have a jury. The next step is real interesting, is picking the jury, right? The jury selection process. It's got a Latin term. It's referred to as voir dire, but it is the process that the defense, the prosecution, the defense, prosecution, and the judge go through to impanel a jury, right? To pick people in society to fill that jury. And remember from discussion before, right? We're interested in ensuring that the folks that get on that jury haven't already made their mind up either way. our juries, our jury of peers, right? So in a sense, they're citizens, right, that will understand what the neighborhood is like, the city is like, county is like. They're from that area, right there. This is their judge. This person accused is going to be tried right in that sense, and so that you got a jury of your peers here. And so we want to make sure that those things are in place so that this jury will hopefully pay attention to all of the evidence, pay attention to all the testimony, pay attention to the actual law, and apply it properly. However, neither the prosecution nor the defense is interested in getting a jury that is fair, right, in the middle of the road, right, not prejudiced to one side or the other as far as a perspective go. As a matter of fact, they're actually focused in the opposite direction. If I'm a defense attorney, I want to make sure that whoever gets picked for this jury is as sympathetic as possible to my client. And if I'm the prosecutor, I want to make sure that whoever gets picked for this jury is a law and order, upstanding kind of citizen as much as possible, right? And with that comes a whole set of perspectives and beliefs and prejudices and ideas and assumptions, and all of those play into this process to who gets picked to be on the jury. Generally speaking, there's going to be opportunities for both prosecutors and defense attorneys to strike people off the jury out of the pool. And they'll do that based upon two factors. One of them is that the judge will give them a number of unqualified strikes, which are basically here you get to, regardless of why, you can take 5 people or 10 people out of consideration for the jury, and the judge will give the same number of strikes to each side, and they don't have to give a reason. They just say, I don't like this person, or I don't think this person is going to be appropriate for the jury, don't want them there, and they're gone. After those strikes are gone, the judge is the only one that will take someone out of the jury pool and remove them. And so it's going to be up to the attorneys to impress upon the judge why this person shouldn't be allowed to be on the jury. Judges are usually a lot more open-minded to putting someone on the jury than either the defense or the prosecution if they're working against it. So, if you can find a solid cause that you convince a judge of, you could still throw people off the jury. The idea generally, though, is that you bring in a bunch of people and you take the first group, and if there aren't any reasons they shouldn't be on there, and the attorneys don't use one of their strikes, they're going to make the pool, right? So there are some people that will be almost always thrown out right at the beginning by attorneys, right? Any other attorney will be thrown out. I've found out that political science professors tend to get thrown out. Anybody that would come across as committed to a particular perspective and wouldn't ever change their mind or be open to change their mind might be trying to get rid of them, right? Because you're looking from each side to get jurors on here that you can convince them that you're telling the best story and that you're providing the best case and that this person's either innocent or guilty. So this whole process is a big exercise in psychology and the application of sociological norms and prejudices and assumptions based on how people look and how people dress and how people talk and people's economic and educational backgrounds. All of those things will feed into this, right? And depending upon which side you're on, you may love somebody or not. You may want somebody or not want somebody. And so it's a pretty complicated, drawn out process. So complicated, in fact, that there are actually law firms out there that you can hire to come in and just do this part of the trial. So that's specialized, right? So again, going back to if you've got the money, there's a ton of expertise out there that you can bring in on your side to help out and get the best representation possible. It's a shame that it's based on that, but it's true. Okay, any questions about that? So let's look at the Eighth Amendment. This is right, the prohibition against cruel and unusual punishment. And our court cases that generally get us talking about this and looking at circumstances are court cases that revolve around the death penalty. And, you know, on its face, it's an easy argument to argue that the death penalty is cruel and unusual. We don't do it very often, although Texas does it a lot more than others do. And the fact that the state is choosing to put someone to death is argued to be cruel on its face. However, the Supreme Court doesn't see it that way at all, right? The Supreme Court does not say, or actually what it does say, is that the death penalty is neither cruel nor unusual, right? Just the fact that it is a death penalty, a penalty of death, doesn't make it cruel or unusual. What would make it cruel and unusual is looking at how we apply it, right? Whether this penalty is applied fairly across the board and done in a way that's just and appropriate. And if it's not, then we can bring up concerns that it's applied unfairly, unjustly, cruelly, or unusually. So anytime if you can prove some form of discrimination in the application of the death penalty to a particular case, then you probably got something to argue on, right? So, you know, the death penalty is our best kind of case scenario for working through this, but it applies other places as well, right? So if you can prove, you know, if you can an argument that the penalty that you're applying is unusual, causes a pain that's unusual or outside the scope of punishment, then right, you could get a cruel and unusual. If you could show torture, right, you could get an application of cruel and unusual to something to prohibit it. So it doesn't have to be just death, but that's generally where we see this kind of argument come from. So court cases have, again, the gist of the court cases has been to try to ensure that especially when the death penalty is a possibility for punishment, that all the I's are dotted and all the T's are crossed and all the processes are done properly, and that we're following a non-discriminatory application of this. One of the real concerns has been that we have proven through research again and again and again that the death penalty is applied discriminatorily, right, in a discriminatory manner. That we do, right, in an inordinate rate, sentence people of color and people that are poor to death at a higher rate than we do Caucasians or people of wealth, right? And it's statistically significant, proven research, right? That's how our system works. So we know, right, that if you're a minority, either based on the color of your skin or you're right poor, and you have been accused of something that would carry the death penalty, you are more likely to get that applied than other folks. In that sense, it's discriminatory, it's wrong, but the courts have looked at that and said, well, that's a true statement. and it's a true indictment of the system as a whole. But this is an application of a civil liberty to an individual. And so you've got to be able to prove discrimination in that trial for that person, right? So even though the courts acknowledge that there's not an equal protection that lies across the scope of this, right, to everybody, they've reduced it to the argument that, look, it's not a, we can't say you don't deserve the death penalty because the overarching picture here is that it's unfair, right? We've got to look at the case, the facts, and the issues in every particular case, and determine that it's discriminatory there. And that's a lot harder to do, of course. It does make sense because, right, anyone that's being charged with a crime where the death penalty is a possibility, everything in that case should revolve around the evidence and the testimony and the issues of what the process that's going on in that case, right? And make sure that if it's discriminatory, it gets brought out, or if it's not, then it's held up that way, right? So they're not crazy on this, but you would think it would bring more insight and more reflection by the fact that we've got this system-wide proof that it does happen. And this is if you're looking at logical arguments, this is, I think, the ecological fallacy that the court is recognizing here, right? That just because you prove something happens in society-wide doesn't mean it's happening in this case. And that's true, and that's logical, and it makes sense. But it would also, I think, behoove one to say we need to do better, because if we can tell it's happening system-wide, then it's happening an awful lot on individual cases, and we need to be paying attention to that. So McCleskey versus Kemp is a court case that tells us you got to look at the individual case. You got to look at the evidence in that case, not the evidence of the societal-wide application. And any cruel or unusual result has to come out of that case, those facts, that process, and not the historical societal-wide case. The Woodson case is interesting because it tells us that crimes cannot carry a mandatory death penalty. What that means is that can't be the only penalty, right? If you're found guilty, you are put to death. And in most cases, we don't do that anyway, but obviously we have in the past. Most of the time, what we see when we look at penal codes that are being applied to these, there are certain crimes that are eligible for the death penalty as part of the punishment. And so the scope of penalty will go from, if found guilty, you may spend this much time in jail, 20 years to life, or the application of death penalty. So a jury or a judge is not put in the situation of knowing right up front that if they find someone guilty of this crime, they've also already committed them to a death penalty punishment, right? And so in that sense, we split the process up. We do guilt or innocence, right, phase of the trial. If guilt is found, then we move into the application of punishment given that guilt has been proven. And at that point, death penalty, if it's a proper type of case, is one of the remedies that's available, right? It cannot be the only remedy that's available. Any questions about that? You make sure that you understand, right, the statistical argument that's made, right, that we know there's problems at all, but the court has told us to stay focused on each individual case. It is a person, not a citizen. Most of the criminal elements of maybe all, I'd have to go back and look one by one, but I can certainly say most of the criminal elements of the Bill of Rights are applied to persons, right? So we're saying that if you're a person in the United States or a state of the United States, these protections apply to you. And that's, that's a good thing in the sense that it hopefully is keeping the criminal system focused more on the actions that are happening and not who's doing it, because this applies, right? They don't have to make the decision, oh, well, it's a citizen, right? Or, since they're a citizen, I won't try to do anything because it's more work, but it's not a citizen, they don't get the same protections, I'll go after them, right? This way it applies across the board as a way to try to keep the government and the state applying the law fairly, right, and not picking out one group of citizens. Now, we know that's still a challenge. We've got problems with that. And we also know that sometimes when we have these problems, it doesn't matter whether it's citizen or person, right? Other things are mattering, right? Whether you're a minority or not, whether you're poor or not, whether you're, other factors that definitely apply here. Personhood or citizenship, not something that they usually know up front, right? So that's a good question, right? Good question. Anything else? All right, so here's a fun one, right? If you ask people, do they have a right to privacy? The answer you get is yes, right? We have an expectation of privacy, although it appears to be dwindling quite a bit, right? Do you have an expectation of privacy when you're on the internet? Those of us that are older probably have the reflexive yes coming out of our mouth before we think about it. Those that have grown up on the internet are probably like, if you understand how it works, then you understand that privacy is nice, but not right, probably not happening. If you're paying attention to federal law that's been passed since 9/11, then you understand privacy. If you had a right to privacy, it's pretty much gone on the internet now. Most of the cases with the federal government and the work that they've been doing to try to protect us is encroached heavily upon this idea that we have privacy, at least on the internet. When you start this question off, right, despite the fact that we assume we have privacy, it's actually a position you have to build. It's a position you have to argue, because there's nothing in the Constitution, there's nothing in the Bill of Rights that says citizens or people have a right to privacy. Right? It's more of an implication. It's more of an extension of an argument. It's recognizing that we have the Fourth Amendment there that provides protection against unreasonable searches, right? You have that, one, because you don't want the government, right, just digging through everything all the time trying to find something wrong. But two, you have it because there's some expectation that in places such as your home, right, the government's not sitting there watching you all the time, right? There is a presumption of privacy that exists in some places. Couple that with some of, right, the First Amendment right to freedom of religion, in other words, the right to free exercise, implies that you can have beliefs that other people, even the majority of people in this country or state, disagree with, and you will still be allowed in your space and in your place to practice those beliefs if they don't go against, right, some really unreasonable or some normal kind of expectations of practice, right? We've talked about trying to accommodate as much religious exercise as we can, and that we look to societies will try to figure that out if it's reasonable or not. So, right, when you look at these, you can then extend the argument or make the argument that privacy should exist. And that's exactly what the courts did. Right, in 65 in the Griswold case, right, the court ruled that there was a right to privacy because these other explicit rights, right, unreasonable searches and seizures, freedom to exercise religion as you see fit, those those to be able to exercise the way they're intended required there to be this idea of privacy. It's really a fairly weak argument as far as basing case law on, and so there's been a lot of arguments against it. It doesn't really hold up well over time, but the idea that it's tapping into is one that we do hold pretty closely. When you're in a phone conversation with someone, or you have an email conversation with someone, and it's directly addressed, or it's, to one person, you write a letter to someone, you seal it in an envelope. Your general expectation is that communication, that expression is going to be private, right? That it's going to get to the other person, and that conversation is going to occur between the two of you. We know that that doesn't always happen, but that is the expectation. Before I move to abortion, right? I want to make sure that you understand that. And we have, through legislation, right, extended a concept of privacy into the working world, into our daily lives, right? Your health records, right, are private. Your educational records are private, right? Your financial records, a good number of them are private, right? So this concept of there being privacy in our society has been held up through legislation, have been promoted through legislation, to say it better, over time, right? As an instructor, right, I've had students, especially early college start students, which are they're high school students, right, in my classes, and I've had parents come to me and say, "What's going on?" And I'm like, "I can't really talk to you, right, about this. Federal education privacy requirements require that I have, right, the student in a college classroom approve this. So I know you're the parent, and I know you're probably even paying for their school, but you're going to have to come back and bring the student with you, and we'll talk about it, right?" So there are these areas, right, of expected privacy, right? You go to your doctor and you expect, or your psychiatrist or psychologist, you expect that visit to be a private visit. You don't expect the government to be interfering in that. However, now we can move on to abortion. When the actions, right, that might come out of that medical procedure could be something as, right, huge as an abortion, there has been, right, a conflict of what's going on here between maybe a right to privacy and a right to protection of life, depending upon how you identify it. And Roe versus Wade, right, the first abortion case that went all the way to the federal Supreme Court, was the one that kind of brought all this out. And it was an assertion, right, this right to choice or right to life was actually brought there as a case on privacy, right? That a person receiving medical treatment and medical advice, that occurs between that person and their doctor, right? And it's nobody's business what's going on there, what the recommendations are, is what the feeling is out of this expectation of privacy. So, right, states had ruled in many different places and in many different ways about this issue. And Roe versus Wade came out of Texas, worked its way to the Supreme Court, and there's conflicting state legislation in place, state laws and state court decisions in place all across the U.S. So the Supreme Court kind of had to take this case up at some point, and then they did, right, in Roe versus Wade. So it's an interesting case to understand, because what you see the Supreme Court doing is going through what is, I guess, best described as a balancing process of different values. So you've got, of course, the state saying that abortion is the ending of a life, and the state's job, the federal government's job, is to protect life. So this shouldn't be allowed. And then you have, right, the argument coming from the privacy side that this is a medical decision and it occurs in private between a person and their doctor, and women should be able, right, to make that decision with that advice of their doctor and go forward with that as a medical procedure. And it's not the business of the government to determine what medical procedure they can or cannot have. So the Supreme Court is, right, has to take this up in a sense and come out with some kind of application that can be applied. So what they did, I think she was Justice Hugo Black. The summer before they took this case up, they'd already decided they were going to. Black spent the summer at the Mayo Institute in Minneapolis. It was kind of cutting edge, right, medical center in Minneapolis. I think it's Mayo. Studying what the practices were, how it's done, what the doctors do, everything, learning everything they could about it. What the limits of medicine were at that time, what made sense, following a timeline of pregnancy, what made sense for what could be done when, and went back and tried to do both things at the same time. They tried to provide a realm of privacy for the woman and their doctor, and personal choice, and they tried to provide a realm where the state did have the opportunity to exercise their interest in protecting life. And this is how we come up with this trimester application of law, right? Because medically speaking, you divide that pregnancy into 3 trimesters, and the medical technology at the time gave you 3 fairly clear places where you could make different decisions. In the first trimester, medical science couldn't do anything there to protect a life. And so the decision from the court is this is the sphere of influence that belongs to the individual and is an area of privacy. And the third trimester, to go the other end, right? At that time, medical technology was such that you could do a lot to preserve, right, a pregnancy at that point, and it could easily be argued to be a life at that point, and the state had an interest in regulating that. And so in that case, the decision was you would prevent abortion except in the case where the mother's life was in danger. And then in the middle, the second trimester was regulation and privacy, right, coming in together, and you're trying to make a decision. So there's some regulation from the state, some scope of privacy for the individual, and so in the second trimester, and that there's a mix. So this is where we started, right? The court is having to define this case, looking at, right, the government's obligation to protect life and this recognition that privacy needs to exist for people, and it's outside or protected from government intervention. So this is, talk about it this way historically, right? We don't talk about the history of this case this way. We talk about how we feel, right? We feel one way or we feel the other way, and the government should do what we feel. And that's not wrong. to approach it that way, but I think it helps if people understand what the government, in this case the Supreme Court, was trying to do. That was presented with this case of trying to recognize two competing values and come up with something that was practical at the time that could be applied, that made sense. And in the early 70s, right, this kind of worked across the board. Since then, of course, things have changed, and the decisions have moved more one way or the other, right? So we can look at some of these cases as we move forward. Right. You'll hear over and over and over again people saying that they don't want their federal dollars going to support abortion, right? They don't want their tax dollars supporting abortion. That hasn't been allowed since 1989. Webster Reproductive Health Services outlawed the use of federal funds, or basically it upheld state laws that restricted the use of public funds for abortions. It applies federal funds as well, right? So the application there has been somewhat spotty based upon the president that's in office at the time, but public funds are not used to support this activity. Most of the people that make that argument really aren't that concerned about the public funds. They just want to stop the action, and the public fund argument is a good way to make that argument. But that's already there for them. We have the court continually recognizing limitations on this privacy issue side of it, where they've said that if you're a minor, you don't have as much privacy, if any at all. So you've got to, if the state says you need to have a parent involved in this decision, then there you are. Then you had, of course, with divorced families, right? One parent might be pro-choice and one might be pro-life, and so you're trying to decide both parents, or so we get a judge in there sometimes as one that can help make the decision on a minor, especially if it's a minor that the state's caring for. So there's lots of practical kind of considerations about when a minor is trying to avail themselves of abortion, what gets put into place. This is the Planned Parenthood versus Casey in the early 90s is a really interesting situation. And it requires me to make you aware of something we'll talk a lot more in depth about in the next chapter when we do civil rights. In civil rights litigation, the Supreme Court had come up with a set of standards to apply based upon what the status of the right was that was being challenged. So what they basically told us is that there's 3 levels of standard that can be applied, and if somebody's civil rights are being violated based on race or ethnicity, the government has to prove that that's an absolutely necessary thing, and the courts have said, we don't think you can, but we'll let you have the opportunity, right? So it's the highest standard possible as applied to race and ethnicity as a scrutiny, right, from the court on discrimination. So if, right, anybody's going to discriminate based on race or ethnicity, the odds are pretty much you cannot prove a good case for that. So that was a compelling state reason. The second level was what was called strict scrutiny, which was a moderate level. And when the privacy argument came in at this moderate level, at this strict scrutiny level. So before Planned Parenthood versus Casey, they said, look, you're going to have a hard time telling us a good reason why we should restrict somebody's privacy rights and allow them to have an abortion. And it's going to be a pretty high bar because we believe this is a fundamental right, this right to privacy, right, which carries the action of being able to get an abortion. And so they had placed that level in the middle, right? It was a moderate level there. Not as high a barrier as race or ethnicity, but still up there. Planned Parenthood versus Casey, right? The Supreme Court changes its mind and says it's not going to be strict scrutiny anymore. It's going to be a standard of undue burden, which kind of flips, right, the whole case. Because if it's a strict scrutiny standard or a crucial, right, the top level standard, then the state has to prove they need and have a great reason for restricting someone's liberties. Undue burden is moving down, right? And now it says not the state having to prove they need to do this, but you, the individual, proving that if they do it, the impact on you will be an undue burden. And this is a big change in the logic of how these cases work, because now, and this is where we still are, right? State governments who have been, right, the government that usually pushes restrictions the most on abortion can do whatever they want, and then it's up to the person affected to come into court and prove that what the state did reaches the level of undue burden. Whereas prior to Planned Parenthood versus Casey, the state had to come in and prove that there was that they needed to do this, while this is an important fundamental protection on privacy, that what they were trying to do as a state was more important. And so now the state can do what they want without having to prove anything, and the individual has to prove the case in court. So they flipped the logic of what's going on in the court case, and that really opens the door, right, to more state regulation. And after Planned Parenthood versus Casey, we start seeing more and more restrictions on abortion come up because we changed the procedure and the standards for what allows it. So after Planned Parenthood versus Casey, you start getting a 24-hour period, waiting period. First on minors, and then later, right, even maybe extended out to adults, right? When they say these things, yes, you can have this. The state can apply a standard here that makes it harder to get an abortion. You still have the court recognizing that this is a right for a woman to have this privacy and to make these decisions, but they're chipping away at it with every one of these decisions, right? And so states are bringing more and more issues up like this. Let's see what I got on the next slide. Okay, so before we move to that, in Texas, which is one of the states that is continually challenging the right to privacy that exists for a woman to control her own body and have her own medical decisions to herself and made in private. Texas is continually challenging that. Our legislature is continually pushing new legislation to try to reduce that right to privacy. And some of the things that we've done, some have been upheld, some have been struck down by the court as being an undue burden. We have required women, right, that want an abortion to be counseled about the medical procedure from someone other than, right, maybe their own doctor. We've required them to be subject to an ultrasound, whether they wanted it or not. We've required facilities that provide abortion as a service. We've required them to change the medical rules and regulations that apply to those facilities. And we moved them from being an outpatient kind of visit the office of a doctor that has, right, a treatment room to a facility that has to have all of the capabilities of an emergency room. So even though there wasn't any proof that was necessary, we've put in procedures in place that require a doctor to have admitting privileges at a hospital although the procedure doesn't take place at a hospital. Some of those, like the emergency room facility, have been struck down by the courts, right? So, but a lot of times it takes so long to get that done that the facilities that do it go out of business because they can't do anything that's against state law while they're waiting for the federal courts to look at the situation. So it's still having the same intended effect, right, of putting these businesses out of business that would deliver this. And if you're um, a pro-life person, then you're happy with the results of this because it's incrementally moving toward what you want, which is the outright outlaw of abortions. If you're focused on pro-choice side of this issue, right, you see the argument that you have a privacy issue here and a right here as an individual to make these decisions. That's being steadily encroached upon by the state and federal governments. So, very live piece of constitutional law here that we're battling out in the states and at the courts, and very, very political, obviously, as well. So it's not just your personal position, also political positions that are facing it, that are bringing this in and debating with this. So it's a really live, really contentious situation. Does everything I said there make sense to you? Any questions about what I'm saying or the way I deliver that, or anything that needs some explanation? I think one thing to keep in mind is that in a lot of these areas where we have conflict between multiple values that the government's supposed to act upon, right? In this case, right to privacy and a right to protect life, right? These are all still evolving cases, right? This is all evolving law. And so, in that sense, it's both a chance for us to understand the issue at a little deeper level, but it's also a chance to see our Constitution and what it means change over time, right? If right, we could argue, I think, fairly successfully that the root decision in Roe versus Wade was, to a great extent, right, influenced by what our technical capability was at the time that the first decision was written. And I would argue that as our medical abilities have extended, it's strengthened the resolve of folks on the pro-life side because they're saying, okay, well, what used to be only possible in the third trimester or part of the second trimester, right? Our medical capabilities allow us to protect life at a much earlier level, and we should change because of that, right? And so technology is impacting what we think is possible, and it impacts what we believe government ought to be involved in or not involved in, right? When our original ideas about privacy were about communications, where we were focused more on verbal communication or written communication, and our thoughts about there being a right to privacy there were a lot stronger than maybe what we think of when we put something in an email or a text. We also thought of that as discrete information, right? You had a letter or a telephone call, and there was no recording generally happening. As a matter of fact, most of our laws were put into place to prevent recording of a conversation without a court giving permission to do that, right? And so, but now as technology has changed and we put things out into the internet that are digitally based, and all of it is saved somewhere, somehow, sometime, right? That's, I mean, the way it works is that this data is being propagated through a system and step by step. So we don't think of it that way because it happens so fast, but the fact is that when you send an email around the world to someone else, there are multiple places that email, right, could easily be captured and held as it's being sent forward, which would then, right, violate your idea of what's private or not. And we know, right, through a couple court cases between AT&T in particular, that the federal government is capturing all internet information that comes into the United States that they do have listening devices on the trunk lines that come across the Pacific and the Atlantic. So while you might have an expectation of privacy, all of that information is available to the federal government. Technically, they're supposed to still be getting warrants to look at it, but they're saving all of it, so that if they want to look at it, they can go get a warrant and then go to where they've saved it. So it's interesting law, right? It's interesting issue at the time.